Good morning. I'm Jerry Sagona, Vice President of Business Development with the Rockford Area Economic Development Council. Today we present a webinar on how small businesses can continue to navigate the pandemic, presented by the law firm of Hinshaw Culbertson. The Rockford Area Economic Development Council is hosting these webinars as a service to our community to provide meaningful information to help businesses reopen and prosper during this pandemic. Please visit our website at www.rockfordil.com for other business resources. There will be 2 more webinars scheduled during the month of June. First, we will continue the Ed Talk series with Rockford University, and then we will present another webinar on legal issues with the law firm of Holmstrom and Kennedy. Please visit our website for the dates and registration details. Before we begin, I would like to give recognition to today's webinar coordinator, Anna Garrison, Manager of Projects and Events with the Rockford Area Economic Development Council. I mention this because there is a tremendous amount of effort required behind the scenes to coordinate a webinar. Thanks, Anna. So let's get the ball rolling. Today's webinar is scheduled for 1 hour, with the last 15 to 20 minutes reserved for questions and answers. Please feel welcome to submit questions throughout the presentation through the question chat function feature on your screen. This morning, I would like to welcome attorneys Jim Keeling, TJ Leak, and Matthew Hevron with the law firm of Hinshaw Culbertson. Jim Keeling maintains a business law practice with an emphasis on organizational and transactional matters, including mergers and acquisitions and real estate. He also advises numerous individual and business clients in the areas of estate and financial planning and real estate development. In conjunction with both his business law and estate planning practices, Mr. Keeling also advises closely held businesses and family businesses on ownership relations and succession planning issues. TJ Leak concentrates his practice in the areas of business transactions and estate and financial planning. Mr. Leak has been involved in advising corporations, associations, and not-for-profit corporate entities on various corporate formation matters, mergers, acquisitions, and governmental issues. He also advises clients regarding estate planning and administration matters. In addition, Mr. Leak focuses his practice on advising closely held and family businesses on ownership relations and succession planning issues. He is active in the pro bono program at Hinshaw Culbertson, assisting various charitable organizations in all aspects of corporate matters. Matthew Hevron is a commercial litigator and transactional business lawyer. He focuses his practice primarily in banking and all areas of debt collection, including residential and commercial foreclosures, replevins, and general collection litigation. Mr. Hevron also has substantial experience in the representation of creditors in bankruptcy proceedings. Mr. Hevron drafts complex loan documentation, handles residential and commercial real estate purchases and sales, represents condominium associations, and practices general corporate law. He has represented many national and state financial institutions, as well as many businesses in conjunction with all of their litigation, transactional, and corporate needs. I would like to now turn over the presentation to attorney TJ Leak.
All right, thank you, Jerry. Thank you everyone for attending. We're excited to present this webinar this afternoon. This is the second of 2 Hinshaw RADAC presentations. The first happened a couple weeks ago, dealing with employment-related matters, and it was well received. I don't know if many of you may have attended that at the same time or not. Today, we're going to really focus on the Paycheck Protection Program loans and the potential forgiveness of those, and then offer some general advice regarding how to handle and plan for continued disruptions in the marketplace related to the pandemic. We have a lot of material, so we're going to try to hit a lot of the highlights and leave time for questions at the end. We wouldn't be lawyers without stating that none of this is client specific, so it's not actual legal advice, but we are pretty confident that we're correct on how we're interpreting the various different rules and guidance and laws surrounding the PPP program. As everyone is aware, this is an unprecedented time. there is so much going on with global slowdowns and shutdowns. The economy is struggling, particularly small businesses with disruption in supply chains, employee issues, the stay-at-home work orders, all of that going on. Because of that, the U.S. government attempted to step in with a stimulus plan, and that was the CARES Act. And so the CARES Act is the Coronavirus Aid, Relief, and Economic Security Act, and it created the Paycheck Protection Program, otherwise known as the PPP. In that legislation, it essentially entrusted the Small Business Administration to administer that program. It should be well noted that the SBA and the U.S. Treasury Department has shown no hesitation in changing and challenging the rules well after substantial economic conduct has actually occurred. Since March 27th, 2020, there's been over 60 pronouncements issued by over 10 different governing agencies, including those that are listed here, regarding interpretations and guidance, some of which actually contradicts prior guidance given. You're seeing the sausage being made in legislation and how it's going to be. It should be noted that those 60 pronouncements really only relating to the PPP program itself. There's been many, many others related to other aspects of the CARES Act. The most recent issuances were interim final rules on May 22nd, which was last Friday. And those two interim final rules dealt with loan forgiveness, as well as review procedures for lenders and the responsibilities of borrowers. We're going to discuss many of these guidance and issues and final rules throughout the presentation today. But however, I do want to also point out that what we are going to talk about today may not be effect by the end of the week. It's changing that rapidly. So the good news with all of this is the SBA has been consistent in its interpretations that it will hold people accountable for the rules that were applied at the time of any action that was taken. So as we're going to harp on many times today, it's really key to document every decision and every decision that you're making. So with kind of that as a background, I want to turn this over a little bit to Jim to talk about the current legislative atmosphere and what's going on in Congress today.
So thank you, TJ. Many of you know that the House of Representatives adopted the HEROES Act, Health and Economic Recovery Omnibus Emergency Solutions Act, a couple weeks ago on May 15th. And if it were to become law, it would be bigger than the CARES Act had been, with over $3 trillion of additional stimulus. But you probably also have heard that it has been declared dead on arrival at the Senate and at the White House. And it goes, of course, well beyond fixing the PPP. Many other things are involved in that act. So what has happened over the last 2 weeks are that there are additional repair bills that are being presented. We expect tomorrow that the HR 6886, the Paycheck Protection Flexibility Act, will likely be passed by the House of Representatives to be sent over to the Senate next week. Next week is when some of the first PPP recipients will be running out of their 8-week periods that we'll be talking about in a little bit. And for that reason, the fixed legislation may not, they have to act before the fixed legislation, and companies really have their ear to the ground as we speak today. We've chosen not to go into the details, and there's 2 bills also that are fixed bills coming through the Senate. We've chosen not to spend too much time at this point in the presentation on the legislation. We thought we would do a better job for those listening in to talk about what's getting fixed when we talk about the problems in the future slides that will be coming for the PPP. So I also wanted to, at this point, do a shout out to slide 31, jot down slide 31, it's other Hinshaw resources. We've issued over 10 client alerts on the PPP process since the law was passed on March 27th. And as a matter of fact, another one is going up yet today. So I guess I should say that's 11. So this payroll or Paycheck Protection Program is quite large. 4.3 million loans have been issued. $513 billion have been loaned out as of the end of last week, with 146 billion left that could be loaned by banks with the backing of the SBA. The current time frame runs through June 30th, and this is one of the provisions that would be addressed to extend the deadline for applying for a loan to the end of the year. You'll recall that the first program went really fast, and there had to be a second authorization. This time it slowed down, and with the controversy of many of the provisions of the program, the size in the first round was 200,000 on average of loans. In the second round, it's 70,000 or 120,000 on average. This is all being done by the SBA, and I looked this up this morning, and the last statistic was 2015. They had 3,293 employees for the whole SBA to run this 4.3 million loans of $513 billion when their budget is usually around $1 billion. One of the banks that Bloomberg's reported had 500 of their 3,200 employees on this program, the SBA program. So this is all outsourced to the banks and financial institutions and lenders. Well, that bank only had 2.2 billion of the 513 billion. So there are a lot of people working on this around the country. One of the commentators has said that when in doubt, pay it out. And I think I'm going to turn it back to TJ to go into the details of the loan program and to highlight some of the remaining issues that we're dealing with as on behalf of clients.
Yeah, thanks, Jim. And so I just want to make sure that, you know, everybody's aware there still is time to apply. We're not going to discuss really any of the application process today, but just know that it's out there and may be extended under the new legislation. So the SBA released its application for forgiveness on May 15th, but at this point in time, lenders are generally not accepting the applications. This is partly because there are still several unsettled areas related to forgiveness of the PPP loans, and that further guidance is going to be extended. As Jim indicated, you know, there's the 8-week covered period under the current statute, and the SBA issued the first loans on April 3rd. So we are rapidly coming up on the expiration of that 8-week period. Commentators have mentioned that the application for forgiveness for banks is going to be probably more time intensive and heavy lifting than what the application to get the loan was in the first place. And while it's not all doom and gloom, there are some prognosticators that are indicating that maybe only 50% of the PPP loans are actually will be forgiven. So which, if that's the case, that obviously would create a lot of harsh feelings and blowback, which I think is where Congress is also focusing on trying to resolve some of the outstanding issues and some of the roadblocks to getting forgiveness. So The bottom line to take away from all of this is while the loan forgiveness applications could be submitted at any point in time, you really want to make sure you're talking with your banker who you worked with to get the loan in the first place to make sure that everything is going to be done. So a little bit on background, the PPP offered low interest forgivable loans. As Jim indicated before, there was an initial setup and it went through very quickly, and there's been a lot of loans approved, but there's still funds available. The key here, and I'm going to read a little bit from the statute, so bear with me, but the PPP loans can only be used for the following expenses: payroll costs, mortgage interest, rent, utilities, and interest on other debts. So payroll costs consist of the following. I'm going to read directly from the statute. Compensation to employees whose principal place of residence is the United States in the form of salary, wages, commissions, or similar compensation, cash tips or the equivalent based on employer records of past tips, or in the absence of such records, a reasonable good faith estimate of such tips, payment for vacation, parental, family, medical, or sick leave, allowance for separation or dismissal, payment for the provision of employee benefits consisting of group health care coverage, including insurance premiums and retirement, payment of state and local taxes assessed on compensation, and for an independent contractor or sole proprietor, wage, commissions, income, or net earnings from self-employment or similar compensation. Interest payments on any mortgage obligation is on real or personal property that was incurred before February 15th, 2020, but not any prepayment or payment of principal of those mortgage obligations. Payment of business rent obligations on real or personal property under a lease and agreement in force before February 15th, 2020. And business utility payments are for the distribution of electricity, gas, water, transportation, telephone, or internet access for which service began before February 15th. So that's a mouthful and what all that is, and we'll kind of break that down as we continue to go along. But again, all of the PPP loan proceeds, in order to even attempt to be forgiven, have to be used for those purposes and those purposes alone. In addition, if there was a refinancing of an SBA economic injury disaster loan, then the PPP loan must be used to do that, because the SBA doesn't allow borrowers to take out multiple loans. So if you had an EIDL and go for a PPP, the PPP must be used to refinance the EIDL. The other standard that's out there right now, which is not in the statute, but it is issued or has been as part of guidance from the SBA, is at least 75% of the PPP loan proceeds must be used for payroll costs. As you may surmise, that is one of the key points where the legislation that's currently pending may change things. There is a lot of blowback on whether that is an appropriate thing. Secretary Mnuchin has said that the intent of the Paycheck protection was to do for paycheck protection and nothing else. So there will be some fight on that. But so more to come on the 75-25 split. So if you don't use those PPP loans for those things, borrowers are subject to penalties for knowingly misusing those funds. There are really kind of two areas where the government can go after you: the False Claims Act or the Financial Institutions Reform, Recovery, and Enforcement Act of 1989. The second one, the FIRREA, really was not used very much, but it was the main tool that the government used after the 2008 recession. And so through those litigations, it should be noted that under FIRREA, in the last couple of years, $9.5 billion have been recovered based on the recession, and under the FCA, only $3 billion. So as it'll be determined how the government wants to go after, and we can talk further about the necessity in just a second. But we do want to note that on May 21st, the Department of Justice did announce that they've announced 2 criminal cases in respect to the PPP loans. So whether that actually goes through or they get dismissed or they turn into civil cases, It'll be to be determined. So there's a lot to go into that, and so the big key comes down to what do you need those PPP loans for, and that was one of the certifications you had to do on your application. I'm going to turn it back over to Jim for a second to talk about the test of necessity.
Yeah, this created a lot of controversy. One of the certifications in the application had to do with the impact of COVID on the business, and when the public companies started taking the money that had access to other financings, it became a big political hot football, and many companies have returned the money to the SBA. As a matter of fact, as much has been going back to the SBA as is going out over the last several weeks. Even though there's 75 or 100,000 more loans that have been made, some of the money has been returned in the like amount. The consternation over FAQ 46, which is one of the things, the way that SBA is communicated is through frequently asked questions, indicated that companies over $2 million of loan were going to get audited, whatever that means. They haven't really determined what that means. And then they also indicated that those under $2 million would be deemed to have filed the appropriate certification as to necessity for the loan in good faith. And really the only audit function might be over actual fraud, and not the certification about necessity. But then in the interim final rule issued Friday that TJ mentioned earlier, the SBA did a 180 and came right back and indicated that they could require that any loan be reviewed for any reason in any amount. And we have in our Hinshaw client alerts that I alluded to before, we have one on impact statements. Impact statements is an internal review by a company of their need for their effects of how they're impacted by COVID. And we feel that that any company of over $2 million certainly should be doing an internally created impact statement, and the details of what should be in that I'm not going to go into now, but they're in our client alert. We've reviewed a number of these for clients. We also feel that it's a good exercise anyway. It's really part of a SWOT analysis of looking at threats and weaknesses, a risk management exercise, and all companies should do this to take a step back and spend a little time on this, so that if you in fact do get audited or review or called to the carpet to explain why your company needed to take this PPP loan, that you're ready and not scrambling at that point of time. That's what I have on that, TJ.
Yeah, so with all of that, it becomes the question of what can be forgiven, and that's the short answer to that is up to the entire principal amount of the PPP loan and any accrued interest is eligible for forgiveness. The SBA and the IRS has issued guidance that said any amount forgiven will be excluded from gross income, so there won't be any cancellation of debt income, so there wouldn't be any double dip there. And the IRS Notice 2020-32 held that they can't otherwise deduct deductible expenses funded with a PPP loan to the extent that the PPP loan is forgiven. So we get now into the actual amount that depends on how much they spend during that 8-week covered period, beginning on the date of the loan disbursement. Now, the interim final rule on Friday provided for what's called an alternate covered period, only for payroll costs, and this is available for employers, with pay periods that are bi-weekly or more frequent. Semi-monthly pay periods do not qualify for the alternate covered period. The first payroll paid during the covered period may include days from before the start of the period and the payment of wages for the last period during the covered period may occur after the end of the 8-week period, as long as it's paid in the normal course of payroll. So if elected, the alternate covered period could potentially cover as much as 9, almost 10 weeks. So what else is really important here is to what is included in these various different categories, which I had read in the statute before. And again, the interim final rule on Friday offered a lot of clarity on some sections, but still left unknown questions on others. So on a couple of the payroll costs, wanted to point out some of the clarity. So bonuses and hazard pay and furlough pay are included in payroll costs as long as the annualized pay doesn't exceed the $100,000 figure. But what is important to note is no reference is made regarding prorating any sort of bonus amount over an 8-week or an 8-week out of 52-week type period. In addition, there's really no clarity on what can be included in what's considered retirement pay. We can deduce that retirement would include qualified 401k, pension, and profit sharing plans, but it's not clear whether or not any contribution of stock to an employee stock ownership plan or a non-tax qualified retirement plan, such as a top hat plan for highly compensated employees or a rabbi trust, would be included. We're hoping that there will be additional guidance on some of that. For forgiveness for salaries paid to owner employees, the guidance in the interim final rule limited it to the lesser of 8/52 of 2019 pay or self-employment income if applicable, or $15,385. This is a per individual cap in total across all businesses. There won't be any additional forgiveness for retirement or health insurance contributions for self-employed individuals. That's including the Schedule C filers and general partners, because the SBA and Treasury has indicated the expenses are paid out of their net self-employment income, and they're essentially justifying it by claiming the self-employed have less overhead expenses because they may not be having the same mortgage and rent that other businesses do. So the general consensus over the last several weeks has been for self-employed or for general partners to maybe take less than the maximum amount of the PPP loan available, although sometimes it's too little too late on that if you've already received the amounts. With respect to non-payroll costs, so this is the mortgage interest and rent payments, you can get full forgiveness on bills paid during the 8 weeks plus what you pay after the 8-week period that relates to the 8-week period itself. Importantly, there doesn't appear to be any prohibition on increasing rent to fair market value if you might have a related or subsidiary type entity that has a loan agreement. But you got to be careful that if you start messing around with that, you do still have that 25% of the loan amount can't really exceed the non-payroll costs. So you don't want to start messing with it too much. So just be careful on some of that. In terms of utilities and utility payments, there's two big areas that are still have questions. Number one is transportation, and we've got no guidance really on what transportation includes. The second is dealing with quote unquote internet access. And the way that it appears to be going at this point is that you can get forgiveness for internet access. So that would be your cell phone or your actual internet service, but it's not going to be able to be forgiven for services that you get through the internet. So any cloud subscription services, cloud computing, anything along those lines, it doesn't appear that that would be there because that's quote unquote on the internet and not internet access. So it should be noted that the items that qualify forgiveness is narrower than what is allowable for the proceeds. So again, you get these timing issues, and you always have to keep in mind right now under the current law and the current guidance, we have the 75% of the forgiveness must be consistent of payroll costs. Stated another way, non-payroll costs cannot account for more than 25% of the forgiveness amount. So now as we get into some further details, and I'm going to kind of go through these pretty quick because the examples are here on the slides that you can look at. We got to talk about a reduction in potential forgiveness based upon laying off or cutting salaries. And there's really two types of tests here. One, the employee test, and one's the wage test. The slide that you see here is really based upon the employer test. And the key point here to keep in mind is you really have to select a method for calculating what constitutes a full-time employee and how you're going to calculate it. So all employees above 40 hours a week would be considered a 1.0 FTE. If it's less, if an employee is working less than that, you have to choose one of two methods. One, you have to look at the average hours and do that as a ratio. So for example, if somebody's working 30 hours a week, that would be a 0.75 FTE. Or you have the election to treat all part-time employees, which is less than 40 hours, as a 0.5 FTE. So when you're looking at doing the calculation here in the employer test, you really need to look at calculating this both ways to determine what's best for you in a potential forgiveness situation. And the key is once you choose which method you're going to do in calculating the FTE, you have to be consistent across the board. For the wage test, you really have to look at this as a per employee basis, and that's whether or not their salary's been reduced by 25% or more. So again, the recently released application clarified that this 25% is based upon an annual salary or hourly wages, so they won't have necessarily double dip against you. So kind of in wrapping all of that up, you know, we got the slide here of you have some potential reductions that are out there, but can you get out of those if you hire everybody back? And so under the current guidance, those reductions are eliminated if you're hiring people back by June 30th, 2020. Now, one of the key points in the interim final rules that came out was that what happens in the situation if you have an employee that was terminated, but now you offer to rehire them back before June 30th and they say no. They will say that there is no penalty for that. They won't ding the employer because that was an employee decision, but you need to be able to document that you followed all the steps in trying to rehire them. And importantly, you have to show that you've actually provided a notification to the state unemployment, which presumably ultimately would get that employee kicked off of unemployment if they said no. So again, these are really key points here, and I went through them very quickly. These tests and calculations, there are worksheets available on the internet. You can either buy some offer them some free. Some accountants are doing it as well as banks. So they have steps to help walk you through it. But it is, the key point takeaway is it isn't going to be a really simple and quick thing. So you need to make sure you keep all of your documentation. And so as part of that application, I just want to enforce again and again, it's document, document, document. So you need to make sure you have all of the information that the application is requesting. That application was released on May 15th, so you can look at it. In addition, there may be some additional documents that the bankers may want to see to be able to do it. That forgiveness, if you look at the application, also has to be certified that everything is true and correct, that the amount that was requested for forgiveness was used for the actual proper purposes, and you need to do it. It seems to be very pro-borrower and seems to allow borrowers to include a lot of costs incurred or before, and the interim final rule kind of clarified that. So you just want to make sure you're moving forward appropriately with that. Once the application is received by the lender, they must issue a decision to the SBA within 60 days. While there is no statutory deadline to submit that loan forgiveness application, you really should make sure you apply as soon as reasonably possible to make sure it gets timely approved. Although with the flux, you don't necessarily have to do it day one after 8 weeks. especially with the new legislation, we don't even know when that time period may expire. So if there is going to be some incentive for the lenders to review all this, because the interim final rule did include some other provisions for the bankers, that if there is an ineligible borrower that is determined, the banks will lose their 5% loan fee. In addition, despite the earlier guidance on the $2 million, as Jim talked about, the SBA is saying we're going to retain all ability to review anything and everything that we want. There are also requirements under the interim final rule to retain all your records for a minimum of 6 years after the forgiveness or after the loan is paid in full. So again, if you end up having to still pay some things over the final 2 years, then you have 6 years after that. So it could be up to 8 years. So as we kind of mentioned, and Jim mentioned as well, not everything was answered on the PPP loan forgiveness. This 8-week start and end point, that may be changed by statute in the flex documents. The definition of owner-employer for a corporation is still somewhat in flux. They've never elaborated on the transportation. And one of the key things that they included in the forgiveness application was the disclosure of any PPP loans received by affiliates of the borrower. What's not listed out there is what happens if you don't have access to all of that information. While there may be some affiliates, the end results and the definition of affiliates, you may end up going into shareholders of some affiliate companies, and they may or may not be as willing to provide the information. So that's a really quick overview, and the key point here is it's still in flux. Things can change. Further guidance will be issued, and we strongly recommend you keep on top of it. Keep looking at our client alerts, or your attorney's client alerts and your accountant's client alerts, and trying to keep going. But I want to kind of transition a little bit into some alternatives of PPP loans, and again, touch on this very briefly because it's really somewhat beyond the scope of this presentation. But there are some alternatives out there for PPP. The Federal Reserve's announced this Main Street lending program for those that really weren't qualified or eligible to participate in the PPP loan. Unfortunately, at this point, the program's not yet operational. We don't know when it will be. Unlike the PPP, these aren't forgivable loans. They will be available for PPP loans recipients. But again, there's still a lot to be found out about this program as it's not yet operational. I'm going to turn it to Matt for a little bit to talk about some alternatives at the state level.
Thanks, TJ. So a couple of different state programs that are available if for some reason you don't qualify for a PPP loan. First one is the Illinois Small Business Emergency Loan Fund. This is a loan fund that's been created by the state. Unfortunately, it is not a forgivable loan, so it is a loan that if you choose to take it out and if you qualify, it is one that you're going to have to pay back. However, it is one that can provide you with a little bit of relief if for some reason you don't qualify for conventional financing or you can't go the PPP route. These loans are up to $50,000. They are 5-year loans for working capital that's provided at 3% interest. Now, those are funds that are provided by the state. However, they're not provided directly from the state. Rather, what you need to do is go through your local lender. The local lender then has to set it up with the state to actually be able to be a provider of those state funds to you. You'll have to file the application. That application gets processed, and if you qualify, then you ultimately get those funds. Now, there are lots of qualifications that exist for this program, some of which is you have to be a business outside of the city of Chicago, but still within the state of Illinois. You have to have fewer than 50 employees, and you had to have had less than $3 million in revenue in 2019. There also is some qualifications that any downfall in your business has to have been COVID related. So ultimately, they'll take a look at your 2019 revenue. You have to have lost at least 25% of that revenue in 2020. And if so, then you could qualify for this loan. Now, right now, the application process for the Illinois Small Business Emergency Loan Fund has been temporarily suspended. A bunch of applications came in. The state's in the process of processing those right now, so they have put a temporary suspension on it, but it's anticipated that that's going to open up again soon. One other program that's available that the state has opened up is the Illinois Small Business COVID-19 Relief Program. Similarly, this is another loan that is not forgivable, but it is, again, state funds that are provided through local lenders. So again, if this is something that you're interested in, you should talk to your local lender about it so they can get signed up if they're not already. These are funds that are lent by the state to banks at a 0.01% interest rate. Unfortunately, those funds don't get loaned to you at that amount. There's some discretion with the lenders there as to what they will loan the funds to you at, but it will not exceed 4.75%. So this is another avenue that you could go to get some funds that may be desperately needed. There's up to $500 million in funds that are available through this program. So there's quite a bit of opportunity that is there. Some of the qualifications are that you have to have less than $1 million in liquid assets, and you've got to be either shut down or limited due to COVID-19. There are some other requirements, but again, if you're looking for some other avenues to get some loan funds in, that's something you should talk to your local lender about.
Yeah, and one other thing to talk about outside of the lending issues, and I'm not going to go through any of these on this slide due to our time constraints, but there are various different tax relief, tax credit provisions that are available. Some are available to all, and some are not available if you received a PPP loan. So this whole slide is probably the subject of a whole nother seminar at a later date because there's a lot here going on. But we did want to throw those out because there are some tax benefits that could be available, so talk to your accountants about it. So at this point, we want to kind of pivot a little bit to give some observations from our perspective on what to do and how to operate your business in the upcoming months. While we're seeing that the stay-at-home orders are gradually being lifted, prognosticators are basically saying that the economy will still be slow, probably into the third, if not the fourth quarter today. So with that, I'll turn it over a little bit to Matt for some of our thoughts, and I'll chime in as we go along.
All right, thanks, TJ. So ultimately, as TJ pointed out, and as we're all aware, unfortunately, even though businesses are starting to open up again as of June 1st, it's not going to all of a sudden just immediately go back to the way things were. It is going to take some time before the economy ramps back up again. It could be months, hopefully not years, but in any event, it's going to take some time. So what can you do to best protect yourself in the meantime in order to keep your business alive? These are some of the things that we're going to talk about over the next couple of slides. So first of all, cash basis budget is something that you really need to think about. You need to think about your vendors and suppliers as well as your customers, and cash is going to be key more than ever going forward in order to make sure that your business can stay viable. Ultimately, when you're talking about your vendors as well as your customers, just like the governor has identified essential versus non-essential businesses, you need to identify essential versus non-essential customers and essential and non-essential vendors. Because ultimately, at the end of the day, you need to make sure that the vendors that are key to supplying the products and supplies that you need are available, can get those products to you so you can in turn get them around to your customers. And part of that is making sure that you've got the cash in place in order to pay their bills, because if you don't pay their bills, you don't have their supplies, and that is ultimately going to kill your business. There are some other items that you need to take a look at, which is really important at this point in time as well, and that is your own loan documentation that you currently have with your lender. So ultimately, you've got to make sure that you can keep the doors open and you've got cash to work with, but you also have obligations under your current loan document. Now, everybody knows that if you don't pay your loan, that's going to cause it to go into default. What not everybody remembers is that there are oftentimes financial covenants that are within your loan documentation, which even if you're current on payments, could cause your loan to go into default. So, for example, there could be a tangible net worth covenant where you have to keep your assets above a certain level and the value of your business above a certain level. There are debt service coverage ratios that are out there that basically say your ratio of debt to assets has to be below a certain level. And if you are in violation of those covenants, that ultimately can cause the lender to call the loan into default, to accelerate the loan, and that ends up being a big problem. So most importantly, what you need to do is take a look at your loan documentation, make sure that you're aware of any loan covenants that are in there right now, make sure that you're in compliance. If you're not, best approach is reach out to your lender and talk to them. Every lender realizes right now that none of their customers are responsible for this pandemic, and everybody's in the same boat dealing with this right now. So lenders are much more apt to deal with proactive customers that reach out to them than if the lenders have to chase them down. So be proactive. If you're proactive, there are several options that are available, including forbearance agreements. You can have loan payment extensions where basically payments can get deferred and put on to the end of the loan. There are interest-only payments that are available. There's a lot of different options that are available, which might help you out, that your lender may be willing to work with you. There's also traditional lines of credit that you can apply for as well. Business interruption insurance. If you have business interruption insurance, now is a very important time to take a look at that insurance and see if this pandemic is covered. A lot of policies don't cover a pandemic like this, but all the more important to read through your policy and make sure at this point in time whether it's covered or whether it's not, because if it is covered, that is a very important source of revenue that you might be able to tap into. Expense deferrals also important. As I had mentioned before, you really need to take a look at your suppliers, your vendors, figure out who you can pay, who you can't, and work with them on payments. Ultimately, just like you're dealing with your lender, you can certainly deal with your vendors and ask for terms. Everybody wants to work with you, especially because the courts have been really, for the most part, for all intents and purposes, shut down for the last couple of months. Now they are opening up again, but I'm anticipating there are going to be some substantial delays in moving forward with cases for a period of time while things get ramped back up. It is very important to work with those vendors to the extent that you can. Lease considerations. Many of you are either tenants under leases or you may be landlords and have your own tenants. Important to take a look at the language in those leases to make sure that you're aware of the obligations that you have as well as the obligations of the other party, whether it be a landlord or a tenant. There are several clauses that are in leases that could potentially be impacted by this pandemic that you need to take a look at. The first one's a force majeure clause. Now, this is a part of often boilerplate language in leases that no one pays any attention to other than us attorneys. until you have a situation like this pandemic that comes up. So now is why it's important to take a look at that lease and see if you do indeed have a force majeure clause. So what's a force majeure clause? Force majeure clause is a clause that basically says there's a situation that has occurred that is not the fault of either party to the lease, that is beyond their control, that's prohibiting the parties from doing what they need to do under the lease. You need to take a look to see if you have that clause in your lease, and if you do, is a pandemic included within the language? If it is included, that clause may very well indeed provide that the parties may be excused from some or all of their performance under the lease for a period of time. So really the specific language in your lease is very important to take a look at that. You can also take a look at that clause to see, is there specific language regarding closure of the leased facility by the government? If that language is in there, that force majeure clause may indeed provide that there is some relief with respect to the obligations of the parties under that lease. Now, usually leases have a couple of other clauses in there regarding quiet enjoyment. Quiet enjoyment really is probably not going to be helpful here. What a quiet enjoyment clause is, it says the landlord is required to provide the lease premises at a quiet enjoyment and such that the tenant can use those premises. Ultimately, the pandemic here wasn't caused by the act of the landlord. This is beyond the landlord's control, so that's probably not going to help. Oftentimes, there's also condemnation clauses in there, and again, that usually applies to acquisition of the property by the government, so that's probably not going to help you out here. So really your best bet is the force majeure clause. But ultimately, if you don't have the ability to get relief under the force majeure clause, work with your landlord, work with your tenant. They're in the same difficult position that you are. And again, best to be proactive. Longer term planning, again, if you have contracts with vendors, with suppliers, with your customers, important to take a look at those contracts, see if there's a force majeure clause in those contracts. Those can be in there just like it within leases. Take a look at the default and termination provisions to make sure that you stay in compliance and to make sure you're on top of your customers if they are not in compliance. You also want to make sure that you track the notice obligations. So if you are in default and you've got a notification requirement, that you're in compliance with that. Lastly, one key thing is check your terms and conditions of any credit agreement that you may have with your vendors and with your customers to make sure that you stay in compliance. If you don't have a credit agreement with your customers, now is a great time to get one, because you want to make sure going forward that it is clear what the obligations are of both sides going forward, so you can stay on top of their payments and make sure that they keep paying. Lastly, we've got bankruptcy that is unfortunately likely to go through the roof. There are some businesses that, despite their best efforts, are not going to be able to make it going forward. So best to protect yourself as best as possible. Preferences are something that, unfortunately, if you haven't dealt with before, you could most likely be dealing with them in the future. So what is a preference? A preference is a payment that is made to a creditor within 90 days of the filing of the bankruptcy, that upon the filing of the bankruptcy, you may have to return those funds that you've received to the bankruptcy estate. And the reason that it is put in place is it's to prevent a debtor from basically choosing their favorite creditor, paying them, not paying anybody else, and then ultimately filing bankruptcy to the detriment of all of the other creditors. So it's a way to basically spread it out. There's a few different defenses that are available, so it's important that you protect yourself to the best that you can right now. One of those is payments in the ordinary course of business. It's important that you stay on top of your customers, make sure that they pay on a regular and routine basis. So if your invoices go out, your customers pay within 30 days, and that's standard for the industry, make sure that they stay on that schedule. If they do, that's an effect. That is not a possible avenue for a defense. If you got a customer that is behind and you're not going to be able to keep that regularly in payments, then one other option is contemporaneous exchange for new value, which in other words is COD. Make sure that your customers pay COD. If they pay COD in exchange for the goods that you provided, then that will provide a defense to preference payments. Lastly, real quickly, the CARES Act has expanded the availability of the Small Business Reorganization Act, provides for an opportunity if you have to file bankruptcy to do so in a Chapter 11 reorganization, much more cost effectively than what was previously under the case under the standard Chapter 11 plan. So hopefully none of you have to go that route, but if you do, that is an opportunity for you.
And finally, on our last topic, and then we'll get to questions. I know we're running out of time here, but the mergers and acquisitions market has pretty much stopped in terms of the pandemic, and there is a lot of questions regarding what's going to happen going forward as the valuations of the companies and the impact of COVID-19 on it, and the valuations and how the EBITDA calculations will be done. This is another real benefit of doing the impact statements that we talked about way back at the beginning, is to be able to explain what happened and what the plan is to get out of it, so that can help you increase value. But the bottom line is keep your eyes open for opportunities. There may be some other businesses that are going bankrupt or going out of business that you may be able to get some assets or customer lists for a relatively cheap price. And also, I would always be remiss if I didn't bring it up, but be aware of your own long-term planning and exit planning, a strategy of when to sell, when to transfer ownership, and the values and the calculation of the values on those things. So reps and warranties insurance has become very prevalent in smaller deals. But they are being very aggressive in reducing or eliminating any sort of coverage for the pandemic because they consider that to be a known risk. So with that, this is the infamous slide 31 that Jim had mentioned way back at the beginning. We've got some websites that Hinshaw has, a whole bunch of client alerts and resource centers for anybody to be able to access and look at various different topics well beyond what we've also talked about today. And the bottom line is all three of us are willing to answer some emails or some calls and help you out with any sort of questions you might have. And so with that, Jerry, I'll turn it over if there's any questions.
Thank you. A lot of questions were generated regarding the PPP loan. First of all, you had mentioned that there's a 75% of the loan amount needs to be covered under payroll. What happens if a business applies for the loan and they can only account for 65% of the loan amount as payroll? What happens to the remaining funds?
I can take that one, TJ.
Okay.
The 65% would qualify if it qualified as the right type of payroll for forgiveness, but it would result in not allowing 25% of other expenses in the other categories to qualify. That would be reduced proportionately. From 25%, it would be reduced to 21.67%. So for the cap of those other expenses, the rent and the mortgage payments and the utilities.
And then a question came in as far as the use of the PPP funds. Can they be used for the purchase of PPE, personal protective equipment for staff use, or if they needed to modify the workspace or building to comply with COVID distancing regulations?
Can I take that one too?
Sure thing, Jim. Go ahead.
Because I wanted to go over what's in these legislative packages. And that's one thing. Under the current PPP, no, you cannot use it for that. But one of their proposals, and we'll have to see what comes out, is to allow for forgiveness of certain expenses which may allow for the growth or adaptation of the business. And that would be the types of things that were listed there. The other points in this, it would be the expansion of the 8 weeks to either 16 weeks or 24 weeks. Sounds good, gives you more time to pay the payroll, but one of the major commentators does give a caveat and said it will make keeping a full workforce in place to avoid reduction of forgiveness much more difficult for many businesses, and thus could backfire in many cases and make calculations more difficult. So we'll see. The application deadline would be December 31st. The loans, the part that's not forgiven, would be paid back in 5 years rather than 2. And perhaps that 25% limitation, as TJ said, would go away as well. And also on the tax front, they may make the expenses deductible and reverse what the IRS came out in the promulgation that TJ talked about.
Another question came up is when we're talking about employee counts, what happens if in an unfortunate circumstance, you have an employee that passes away during this period? Would they count as a reduction in force?
Well, I guess, Jim, I can take this and you can chime in if you disagree with what I'm going to say is at this point in time, I haven't seen any specific guidance on that situation, but it's been consistent with the SBA that they're not going to take into a penalty anything that was outside of the employer's control. So if it was an employee who passed away or an employee says, I'm not coming back to be hired, then that's not going to be counted against you. But again, you just need to make sure that you document that as it goes through with the FTE count.
You're right on it, TJ. That's what the commentators that we've been studying have said as well. They haven't said, SBA hasn't said it directly, but the provision in the rule issued last Friday is borrowers should not be penalized for changes in employee headcount that are the result of employee actions or requests and other things beyond the employer's control.
Another question came in regarding the interpretation of restoration of the reduced wages. Is it correct that you must restore wages that were reduced during the coronavirus term by June 30th?
Yes.
Yeah. Although it should be noted that June 30th may be one of those periods that gets extended under the new legislation.
Good point. And then finally, our region has been very active in getting the information out on various programs. And so companies were offered both PPP and the EIDL programs to assist their businesses. Is it correct that a company cannot receive both of those, the PPP and the EIDL?
You can receive both, but when the forgiveness is done, if you got a grant, the amount of the forgiveness will be reduced by the grant. The $10,000 grant.
Okay. So there was a question about repeating the specific forgiveness guidelines for the salaried employees. We'll have the presentation available online, so that person can just check our website and get to that information. And then finally, it says it's been discussed that employers can give employees a COVID bonus, use up the payroll loan amount. Is that true?
So the short answer is bonuses would be included as well as hazard pay. But I think, from a big picture perspective, I think you just need to be careful about it. And as I mentioned in the presentation, there hasn't been any guidance on whether bonuses need to be prorated or not.
Be sure it smells right.
Well, that wraps up our questions. I'd like to thank our panelists for a great presentation and our audience for participating today. Please remember to check RADAC's website at www.rockfordil.com for business resources and upcoming webinars events. Have a great afternoon. Thank you.
Thank you.